Hello and welcome to the Minimum Competence episode for Wednesday, April 1st, 2026. I'm your host for today, Andrew Leahy, an assistant teaching professor of law at Drexel Klein School of Law. On today's episode, a judge halting Trump's White House ballroom, SCOTUS weighing birthright citizenship limits, and a court rejecting an IRS church endorsement deal. Let's remember, war does not determine who is right, only who is left. And read today's legal news. On this day in legal history, April 1st, 2005, a major shift in the structure of the United Kingdom's legal system began with the passage of the Constitutional Reform Act of 2005. This legislation fundamentally reshaped the relationship between the judiciary and other branches of government. Before the act, the highest court functions were carried out by the Appellate Committee of the House of Lords, blending judicial and legislative roles in a way that raised concerns about separation of powers. The reform sought to modernize the Constitution by clearly distinguishing judicial authority from Parliament. It also redefined the role of the Lord Chancellor, stripping away many of that office's judicial and legislative functions to reduce institutional overlap. One of the most important outcomes of the act was the creation of the Supreme Court of the United Kingdom, which would eventually take over as the country's highest appellate court. Although the court did not begin hearing cases until 2009, the legal foundation for its existence was firmly established on this date in 2005. The reform also created a new Judicial Appointments Commission designed to make the process of selecting judges more transparent and independent from political influence. By doing so, the act aimed to strengthen public confidence in the impartiality of the judiciary. The legislation reflected broader constitutional trends toward accountability and institutional clarity in democratic systems. It also aligned the UK more closely with other nations that maintain a clear separation between judicial and legislative bodies. Critics at the time questioned whether the changes were necessary in a system that had long functioned without a formal written constitution. Supporters, however, argue that the reforms were overdue and essential for maintaining the rule of law in a modern state. Over time, the changes introduced by the act have become a defining feature of the UK's constitutional framework, shaping how justice is administered at the highest level. A federal judge in Washington, D.C. blocked plans by Donald Trump to build a large ballroom on the White House grounds, granting a preliminary injunction requested by the National Trust for Historic Preservation. Judge Richard J. Leon concluded that the nonprofit is likely to succeed on its claim that the administration acted beyond its legal authority. He emphasized that Congress had not approved the project and no statute gives the president power to construct new buildings on White House grounds without authorization. The court relied in part on the Constitution's property clause, which gives Congress control over federal land. The judge rejected the administration's argument that existing statutes or agencies, such as the National Park Service, provided sufficient authority. He also criticized the government for shifting explanations about which entity was responsible for the project. The lawsuit stems from the administration's decision to demolish the historic East Wing and move forward with construction without completing required reviews. These include environmental assessments, planning approvals, and congressional authorization. The court found that the potential harm to the White House's historical and cultural value justified immediate intervention. The judge also dismissed claims that delaying construction would create national security risks, calling those arguments unpersuasive. Although the project was described as privately funded, the court said that funding sources do not override statutory limits. As a result, construction must stop unless Congress explicitly approves the project. The judge temporarily paused enforcement of the injunction to allow the government time to appeal. The Supreme Court of the United States is considering whether Donald Trump can restrict birthright citizenship through an executive order, a move that could significantly change how citizenship is granted in the United States. The policy would deny citizenship to children born on U.S. soil if their parents are neither citizens nor lawful permanent residents. Lower courts blocked the order, finding it violates the 14th Amendment to the United States Constitution and existing federal law. The justices are now reviewing that decision on appeal, with a ruling expected later this year. At the center of the dispute is the meaning of the Citizenship Clause, which has long been interpreted to grant citizenship to nearly all people born in the United States. The Trump administration argues that the phrase subject to the jurisdiction excludes children of undocumented immigrants or those in the country temporarily. Opponents contend this interpretation contradicts over a century of legal precedent, including United States v. Wong Kim Ark, which affirmed birthright citizenship for children of foreign nationals. The case could have far-reaching consequences, potentially affecting hundreds of thousands of births each year and requiring families to prove a child's eligibility for citizenship. It also reflects broader debates over immigration policy and constitutional interpretation. The Supreme Court's decision will determine whether the long-standing understanding of birthright citizenship remains intact or is significantly narrowed. A federal judge refused to approve a proposed agreement that would have allowed churches to endorse political candidates without losing their tax-exempt status. Judge J. Campbell Barker ruled that he did not have jurisdiction to sign off on the deal between the Internal Revenue Service and several religious groups. The agreement sought to carve out an exception to the Johnson Amendment, which prohibits nonprofits from supporting political candidates. The judge based his decision in the Tax Injunction Act, a law that generally prevents courts from interfering with tax collection. He reasoned that approving the agreement would effectively limit how much tax the government could collect, placing the case outside the court's authority. The proposed settlement had been designed to resolve a lawsuit brought by religious broadcasters and churches challenging the Johnson Amendment. Supporters of the ruling argued it preserves the long-standing separation between political campaigning and tax-exempt religious activity. Opponents, including the groups that brought the lawsuit, say they plan to appeal and believe an exception should be allowed for religious speech. The dispute reflects a broader legal and political debate over the balance between free exercise of religion and restrictions tied to nonprofit tax benefits. With that, and as always, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than Minimum Competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it's certainly never that. Minimum Competence is available at minimumcomp.com and wherever it is you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, only the dead have seen the true end of war.